getting on? I'll just bat on. My customer hates me. It's all gone horribly wrong. My colleague said, why is the woman smiling? I don't think she's smiling. It's more of a grimace to me. And she's got glasses on to stop the spit. Another real anecdote, I had a client who came in to see me, I hasten to say after it had all happened. Got a new business in the IT area. Went and negotiated. Yeah, we'll do that. We'll install all this stuff. They thought they'd worked out what they were going to do. After a while, things weren't going quite so well. Thing wasn't, being installed properly. There were extra problems they didn't know about. Things about their computers and about their business that they hadn't been told. So it got more complicated. So he was saying, look, this is not what I thought I was getting into. It's more complicated. It's taking me more time. I need more resources. The customer's saying, well, I told you all about this. Didn't you listen? Don't you remember that meeting that we had when I told you that this was such and such and such? So they start falling out. My client's saying, I need to increase the price. I'm very sorry, I didn't know about these things because you didn't tell me. Well, I did tell you because it's in the spec, but it isn't. And so it goes on. And the really bad thing was that the customer then said, I want you off the site. Get out, I'm sick of you, and I'm going to get someone else to come and fix it. And when they fixed it, I'm going to give you the bill. So not only did they not get paid for the work that they thought they'd done, but they now got a bill from a very angry customer who's got somebody else, even more expensive, to come and fix the mess. How can this happen? Intelligent, sensible people. It happens all the time. The biggest IT cases in the High Court are in situations like this. Obviously much bigger numbers, local authorities and health industries and so on.
I think the most notorious are the agencies, freelance agencies within the IT industry, and you were talking about the ownership of copyrights, intellectual copyrights. Most of the employment agencies, if you are working through them as a freelance IT engineer, consultant like myself, which I've done quite a few times, they have their clauses that anything that you do on the client side is owned by us. And when you're working on the client side, they may have their clause that anything you do on our side is owned by us. So who actually owns anything? That
well, that's it's they should have an automatic assignment clause in their terms to say that anything.
Because end of the day, all I'm interested in is making some money. I don't give a damn about what I'm doing, as long as I get paid. But you end up with a baby. Everyone wants to have it.
That's right. You can try cutting it in half, I suppose. But this scenario is slightly different because we're not just talking about IP, we're talking about anything that could go wrong. And I don't want to, people say, oh, you must have terms and conditions. T's and C's, they now say. Have you got to? People say, well, do I really need terms and conditions? People want something, they want some chutney and they buy it. That's it, that's fine. That's okay. But what I want you to do is to think about the fundamentals. So forget about all the legal flummery for a minute. There we are. What have you agreed to do? It's sort of a simple question, but so many people don't really think about it. What have I agreed to do? How much am I going to charge for it? Is the price fixed, or is it going to change in certain circumstances? What are those circumstances? When am I going to do it by? So when are you expecting it to be delivered? Have you really clarified it, what the expectations of the parties are? And then you need to have evidence of this, evidence of what you've agreed. And emails are fine. People used to write letters to each other, but now it's all on emails. That's fine. You can create a contract. Contract is an offer to do something and an acceptance by the other person that you will do that thing, whatever it is. So don't get sort of obsessed by terms and conditions and sort of legal stuff. Think of the fundamentals. And if you're in a complicated business, like a consultancy, where you might be doing complicated things on somebody's site, you've got to be really, really careful about what exactly it is you are doing, what resources you need from them, how much it's going to cost, and so on. So don't make them, don't get into the situation where they say this old, don't you trust me kind of argument. It's all clear, we know what we're doing. Well, they won't. You know, you can have two people in a room having a discussion and you get three versions of what's happened. Don't take anything for granted. And then when you talk about the more legal stuff, you get all this kind of stuff, warranties and indemnities and T's and C's and so on. And in the IT world, you have specifications and acceptance criteria, and it gets quite complicated. But basically, the fundamentals are just the same as I've explained them. There just gets lots of extra legalism all around it. And people get insurance for things that go wrong and so on. But yeah, if you're doing business to business, you do need terms and conditions, really. They can be quite short. They need to be 20 pages. It's not so easy if you're dealing business to consumer, because consumers have lots of rights, and terms and conditions tend not to be worth very much when you're dealing with consumers. Business to business, yeah, think about it.